presentation, I did a Google short link where I put all the things that I talked about, see appendix. You weren't crazy, it wasn't in your printed out materials. It's just a quick link. It goes to my Dropbox account. You can download, I think, 12 or 13 of the documents, LEOs, some of the cases I talked about, and whatnot if you want to supplement your materials. Like I said, my name's Kellam Parks. I am an attorney. I have my own law firm that I founded about 3 years ago. One of the reasons I went to my own law firm is to be sort of the cutting edge of technology. I use cloud-based practice management systems. I'm a paperless office. I try to use technology as much as I can. I use my iPad for trials. I did a jury trial about a year ago. It was a 5-day jury trial. I used my iPad. The other side had 14 banker boxes full of documents. There's a lot of advantages to having word searchable documents and whatnot. I sort of fell into this topic of, in doing that though, there are ethical challenges. There's sort of what you can do, what you should do, best practices. I had the good fortune to present a CLE with Jim McCauley from the Virginia State Bar last April, and some of these materials came after that, and I update them. So I've been a litigator my whole career. I've been practicing almost 15 years, and it's really, I do this stuff every day, and I write about it. I'm on the Virginia State Bar's Tech Committee, so I do a lot of these things, research it, I keep up with it, and really we put this together to try to share it with you guys to do the same. Alex, I hired Alex about 2 months ago. He was a career prosecutor, been practicing a little over 6 years. I like to tell my clients that he's probably tried more cases than I have. As a prosecutor, he's in court every day. I was able to convince him to come over to civil practice in part because of the wireless and modern technology that we do. So Alex had a big part in putting these materials together. He helped me update it. He's the one that put together most of the hypotheticals so they made sense. So without any further ado, I just want to jump right into it because I know we have a 2 o'clock deadline, so you could do the other presentation. So when we talk about modern ethical issues, that's me, that's Alex. So obviously technology has changed the practice of law. It seems like almost every day, you know, first it was the cloud, and we'll talk a little bit about what that means. But even back in the day, it went from, first you had computers. And I'm old enough to have partners that are old enough to have never used not used a computer, barely used a typewriter, then slowly dragged into the modern age. But with technology, it disrupts pretty much society as large, but especially when you have a profession like law, because it really, unintended consequences happen, and you really need to be on top of what happens. In fact, one of the things that we talk about is must-use lawyers use technology. We have a couple of cases in the materials that sort of tease this out a little bit, and one of them is Munster v. Gross, which is a 2005 case where the lawyer was admonished for not using Google to find a non-resident defendant after filing a long-arm affidavit asserting that they couldn't find the case. So basically what happened was this lawyer tried to save the filing by saying, look, I couldn't find him. I had to do this long-arm affidavit. And the court, back then, Google was there, just not as big. They Googled it, and in the case it even says, using Google, we found these addresses. And so the lawyer was admonished. A more recent case is Griffin v. Maryland, where a court approved a statement found in a law review article that states that it's a matter of competence for lawyers to investigate social networking websites. For instance, when I do a jury trial, I actually do an investigation of all of my potential jurors before I even get to the court. You have a large list. The court is, I think the code says you're supposed to, within I think either 2 or 3 days, have a shortened list of potential jurors from the overall call list. Some courts do that, some courts don't. You kind of have to push them sometimes. When I get that smaller list, my office investigates them. They go into Facebook, they Google them. They do not link in. We don't use LinkedIn, and one of the reasons why, and we'll get into a little bit later, is that when you look somebody up on LinkedIn, it actually tells them, it could potentially tell them that you looked them up. And the courts have found that that may interfere with the jury. So you're allowed to look them up as long as they don't know you're looking them up, which seems a little counterintuitive. You can't pretend to be their friend to get their friend, that kind of thing. in my personal opinion, I think that it's a requirement to be a good lawyer and be effective for your client to do this kind of research to make sure that you know what your potential jurors are. Once the jurors are chosen, of course, if you have the staff back at the office, in the last jury trial I did, they went a step further and did more investigation, so I really knew who I was speaking to. It's not ethically required yet, but I think it certainly is something to think about. So do you have a duty of technological competence? The ABA Model Rules 1.1, Comment 8, back in 2010 it was amended. And it added the language, which is italicized, saying including the benefits, basically you must keep abreast of changes in the law and practice, including the benefits and risks associated with relevant technology. What's interesting, and by the way, there was in the materials we talk a little bit more about that, but there is, when you go through, the accompanying report says that it's not a new duty. They're just sort of fleshing out that, hey, by the way, that means technology. What's interesting is, since I first started speaking about this last year, we now have a pending amendment to Virginia's Rule 1.1 that in essence adopts this rule. So Virginia is slowly, and I'm fairly confident it's going to pass. And really what it just does is it puts people on notice. You need to understand what's out there, and you need to be able to represent your clients to the best of your ability. And that includes being able to use technology. I've encountered some older, and it tends to be older, I don't mean to stereotype, it tends to be older attorneys that say, I don't use, for instance, I like to share documents via Dropbox. So if I have a lot of discovery, I say, look, I'm digital, I'll just send you a link, you can just download them off my Dropbox account. If it's particularly sensitive, I'll even encrypt it so everything's fine. And I've had attorneys say, oh, I don't do the Dropbox. I don't do that. Take it one step further. I've even had attorneys say, no, I don't want anything digital, so I'll mail you the CD. No, I prefer paper. And I'm going to give you paper. I said, well, I don't want paper. Can you just send, I'm just going to scan it and throw it away. No. So if they don't do that in the normal course, how are they possibly going to know how to research people online? When you go to court, especially with jury trials, your job is to persuade the jury. The old days where you can just sort of big whiteboards and that's all you've got, you're not very persuasive. Juries, as long as you know how to do it and do it right and don't make mistakes, they enjoy the technology. It really helps persuade them, and it really gives them a sense of interaction with your case. So you do have an ethical duty, in my opinion, to be competent. Now, you don't have to be on the cutting edge. You don't have to use every newfangled technology, but you at least have to know what's out there. So next thing we're going to talk about is some of the social media forums. I'm going to have Alex talk about that, and he'll walk you through some of those.
Follow along on my device if you want. Oh, you just hit the enter key?
No, just the arrow key right here.
Oh, okay. Can y'all hear me all right? Okay. So the first thing we're going to do is go through a brief overview of sort of what is out there in terms of using the internet, social media, research tools, and the like. This is by no means an exhaustive list. There are plenty of things I don't cover in the outline. One of them being Dropbox. I know I had a request to talk about it a little bit more from someone who should be here today. So I'll get to that when we talk about cloud computing. But as for right now, I'm sure everyone in the room has heard about blogging. I was curious this morning as to where the word comes from, and it's a contraction of weblog, and that is exactly what blogging is. It's basically you're maintaining a journal, a diary, a log, an article base on the internet. There are plenty of blogs outside of the legal field. They're too numerous to name. There are also plenty of them in the legal field. As of 2 years ago, more than 3/4 of law firms were blogging. So it's certainly, I think, now the norm with the large organizations, and it is a pretty strong marketing tool to use. And here's a list of some of the top 100 blogs to check out. It's compiled by the ABA. The blog is on the left, the list is on the right. or the hyperlink to it. These are just a small sampling of them. There are some that are more politically motivated, some that are field specific, and this is by no means the only media that they're in. So these are all standalone websites. You could probably include articles on LinkedIn, posts on Facebook, even pinning things on Pinterest as a form of blogging. But in essence, this is writing a journal on the internet. Next, we move into the social media section of this presentation. First thing we're going to talk about, because it came first, is LinkedIn. And what LinkedIn, in essence, is a professional online Rolodex. I'm not going to use the term Facebook because we're talking about that next. But LinkedIn, and that should say May 5th, 2003, had humble beginnings in someone's living room. And now it has hundreds of millions of users worldwide. And many attorneys use this. They use it for marketing. They use it for references, sometimes even research. But as Kellam has said, and having a LinkedIn account, you can tell when someone's looked at your account. So keep that in mind as well. Facebook is the largest social networking site in the world. As of 2013, it has 1.3 billion users. That's like 4 United States of Americas are all on Facebook. It's worldwide. It's not quite as hip as it used to be a while ago, but this is the blue standard of social networking that everyone knows. And it's also a gold mine for evidence, which is what we're going to talk about later on in the presentation. Facebook, in its essence, is a pretty simple site. It's like a picture-in-paper Facebook. You put up your picture, some information about you. You have friends. You can like different things, potentially other attorneys or clients. The next one is Twitter. I have to confess, I do not have a Twitter account, but many people know what this is. In essence, a Twitter is a derivative of a blog, but you have a very short character limit. It's only 140 characters. A lot of people use it to sound off, but as you can see, 645 million active users, which is twice the population of the US approximately. It's certainly a gold mine for marketing as well. A couple of I guess newer to the game forms of social networking is Pinterest, and there are a few similar type photo-driven social media as well. Pinterest, you will post or pin photos on the internet, and it is totally photo-driven. You can comment on them, but by and large, it's all pictures. And some attorneys have hopped onto this recently for the obvious marketing benefits. And so what's trending? What's new in social media, or things that lawyers may potentially use to market themselves in the future? A new trend I saw in prosecution some as well, is disappearing social media. So Snapchat, you send a photo, it disappears, and it's never to be found again, and that's what the logo is for, by the way. There are a few other ones, since many people have bought smartphones that are location-based, that use something called crowdsourcing, or essentially asking for volunteers over the entire internet user populace. So some of these, like Chirp, if you walk by a place, it'll activate something in your phone. And Feed is similar to Facebook, except you can charge people to look at your postings. Now, a lot of people use social media casually. I hate to stereotype as well. This hits a lot of younger people coming out of law school. But the first question a younger, really any attorney should ask, how do the rules of ethics apply to social media? And the answer is, well, the same as any other media. So keep that in mind so you don't get into trouble. So the rules of professional conduct that doubly apply to social media: competence, as Kellam was talking about earlier. You have to know what's out there both to know how to use it to your benefit and to avoid messing up. The second one is confidentiality. You don't want to put your client's information where it doesn't need to go. So posting client confidences on Facebook, probably a bad idea. Prospective clients. These are all pretty powerful marketing tools. All of the services I just listed were free. So you could reasonably expect to get clients off of social media. Access to evidence is a big one. There's a published case which we'll discuss further in the presentation that has to do with removing a social media account or altering it. Another one is complying with discovery. If you've put it out there, you may have to turn it over. Communicating with jurors is another rule that applies. Communicating with judges, they're on social media too. Communicating with someone who has an attorney, if you're an attorney. The pretext search that Kellam was talking about, pretending to be their friend to get at their stuff. Advertising rules. And finally, you have to know what your staff is doing. Anything that your staff does is imputed to you because they're considered to be your servant. So definitely keep that in mind. So these are some boneheaded mistakes that people have made in the past on social media. Comment on pending trials to jurors or as a juror. You criticize judges. It's unethical to recklessly criticize them. You put privileged client information on social media. People can expose themselves to defamation claims if you commit slander. This is one that can also just be applied to normal technology such as a telephone. We've all gotten it before. A family friend asks, hey, I need to talk to you about this, and before you know it, they're telling you about their nephew's DUI case and asking you for, I just need some information. The same thing goes for social media. You could be violating advertising rules depending on how you use social media to market if you don't use disclaimers. Someone from North Carolina calls you and you give them legal advice, you could technically be practicing law where you're not licensed. Everyone's downloaded a computer virus before. Judges, again, are on social media. The pretext investigating. And again, make sure your staff is not doing any of these mistakes. And so this is one, and this is a real judge. You can feel free to look her up online. In Texas, judges run for election. Her website is actually very easy to use. She's on several of the social media forums we've discussed. But she gave a talk, and essentially the theme of her talk was, hey guys, we're watching. So keep this in mind when you're asking for things in court. For example, a prosecutor practicing in front of her wanted a weeks-long continuance to go to a funeral. Perhaps while they were at the wake, they posted photos of themselves drinking heavily. Judge saw it and confronted him about it in court. Lo and behold, when they asked for a continuance later, it was denied. As a result, the prosecutor defended the judge. So keep that in mind. This is one that there are any prosecutors or defense attorneys in the room chill your spine. But someone posting evidence on the internet of an open investigation, generally frowned upon, but this person saw fit to put it on Facebook, commented about it, and my memory serves, the comments were criticizing the law enforcement's work. Also not a good idea, and the judge admonished them that no one seems to be thinking that when you get that motion for discovery, this is going to come up and it's going to haunt your case. The simple answer to this question is yes, it can get you in loads of trouble. So there was a juror in Detroit, and there was a criminal trial, and before the trial was over, during the trial, this juror posted, it's going to be fun to tell this defendant they're guilty. Lo and behold, the defense attorney's son is on Facebook, finds this post. And the juror was found in contempt, fined $250 and ordered to write an essay. And while that seems like getting off pretty easily, contempt is a jailable offense in Virginia as well. So that is very much a possibility. I believe the offense in this case was fairly minor, But if this had happened in, say, a murder trial, you may have seen a different outcome. So these are two other examples. A public defender of 19 years kept a blog and revealed all sorts of incriminating information about her clients on the blog. What did they do to her? She got fired. She was disciplined by the bar. So you have to remember Rule 1.6, and that's one of the big rules to remember. Don't put your clients' confidences on the internet. Once you put it out there, you have no expectation of privacy in it. The whole point of these websites is to publish your persona. So when you post it, unless they've given you permission, you've probably committed a rules infraction. All right. Now, in 2013 in July, all of the former advertising rules were rewritten, and they were, if you look at them as a whole, Rule 7.2 was deleted, Rule 7.6 wasn't adopted, so you only have 4 rules you're working with. But essentially what the authors of the rules did is they recombined the rules into a medium-neutral format. And that's what Kellam's going to talk about right now.
And I should have said this initially too, that pretty everything that we're talking about here is in our materials and more. So don't feel like you have to. I hate when somebody doesn't say that at the beginning, but in case anybody is feverishly taking notes, which I don't think you are, but that's okay. Next is communications and advertising. So, sometimes if you work for a larger firm or your public defender or your prosecutor, you don't really think about advertising. I'll tell you, going from a larger firm and then starting my own firm, it's a big thing to me. I spend a lot of time marketing and thinking about advertising because that's how I get clients and therefore feed myself and my family. So the rules, as Alex said, were rewritten in 2013, and they're now medium neutral. They apply to all communications. And the rules were written in part so that you don't have to worry about, well, what happens if it's an internet post? What happens if they just struck it all, and now how it's written, it just applies to everything. Rule 7.1 deals with communications about our lawyer's services. Rule 7.3 deals with direct content with potential clients. Rule 7.4 deals with fields of practice and certifications. Rule 7.5 deals with lawyer firm names and letterheads. And let me also say that everybody's read the rules before as soon as they got practice. Maybe you'll go and look at a rule every now and then if something pops up. I had a potential conflict of interest. I had another attorney on the other side of a case try to disqualify me because my former firm handled the case years ago. And I do what all people should do. If you're curious, just call the bar. They have an ethical hotline, by the way, if you don't know, and now they take them by email. And it's this whole separate division, by the way, than the enforcement. So nothing that you tell the ethical hotline could ever be used against you, even if you call up and go, hey, I think I just breached some ethics. And if they say, yeah, you did, you're not going to get in trouble from them at least. But in any event, I had to look up a rule. I make it a practice that I read the rules at least once, if not twice a year, just to refresh myself. Especially if you're on your own or a smaller practice, stuff pops up all the time. So you really should stay apprised, especially and pay attention when they tell you new rules are going to be amended because they can really change the landscape. And what you think used to be the rule may not be the rule anymore. So let's talk about advertising case results. Rule 7.1b applies to this. Basically, you have to have a disclaimer, and the disclaimer must put the case results in a context that's not misleading or even potentially misleading. You have to state that the case results depend upon a variety of factors unique to each case, and you have to state that the case results do not guarantee or predict a similar result in any future case undertaken. And so if you go to the internet and you go to pages where they talk about hey, these are our representative cases, you're going to see this block text. You're going to see something along these lines, or at least you should, and if it's not on there, then they're violating the ethical rule. But basically, it's a disclaimer. And there's been some discussion about, in today's society, do they really think that if they hire you, they're going to get $1 million, that they don't really know the cases? But it's almost a least sophisticated consumer-type standard. The bar doesn't want to parse hairs about how experienced or intelligent your potential client may be. So bottom line is you got to put the disclaimer on, even if the case you were talking about had to do with somebody that died and the person that's coming to you broke a tooth, eating something at Taco Bell. Clearly they don't think, but the bar don't want to get into it, so you have to do a disclaimer. I want to talk to you a little bit about the Hunter v. Virginia State Bar case. I actually went to school with Horace Hunter. He's a friend of mine. And I talked to him at length about this issue. And Horace is an interesting guy. He's a stubborn guy. And a lot of people, when the bar tells you to do something, a lot of them, as a business person, even if I didn't think it was right, if I don't necessarily have some big rah-rah First Amendment thing inside. I mean, if at the end of the day I look at, well, I could spend tens, if not hundreds of hours fighting the bar on this and maybe get sanctioned, or I could just do what they want. A lot of people do what they want. The bar, supposedly is looking out for everybody, and that's a good thing. But Hunter said, you know what? No, I'm not doing it. And what the case had to do with, and we talk about it more in the materials, and I also gave a copy of that in the appendix, the actual Supreme Court case. But there, Hunter, who's a criminal defense lawyer, blogged about past victorious cases on his website. He had a blog talking about defense in Richmond. The post included names, evidence, charges against him. This is all post-trial. The Supreme Court of Virginia, and he went through the whole process. Basically, there was a bar complaint. The bar said you need to put a disclaimer on there, and you shouldn't be talking about these cases because it embarrasses your client. And they said it violated all these rules. He fought that, went up, and then finally took it to the Supreme Court of Virginia. And the Supreme Court found that what was former Rule 7.2a3 was constitutional as it applied to the blog and was properly regulated speech. Because thus the lawyer must post the disclaimers. Rule 1.6 is what the Virginia State Bar said that he had violated. The Virginia Supreme Court said, no, actually, he didn't violate that particular rule. And what that had to do with was that you can post information previously disclosed in a public courtroom once the case is closed. So what had happened is Horace represented somebody, afterwards said, hey, great victory for my client. He was charged with this. We went before a jury, went before the judge, and I won. Well, the client didn't like that. They were embarrassed that on his blog was his case, or her case. I can't remember who it was. And the bar said, because of Rule 1.6, you're not supposed to embarrass your clients, that type of thing. And the Virginia Supreme Court says, no, that's First Amendment. It's an open courtroom. Anybody who was there that day knew what happened. It's not a closed, sealed file. It's not a juvenile case. And so First Amendment wins over a potential embarrassing client. Now, I will say I don't particularly think it's a great business practice, because you've alienated a client and certainly not going to refer any more business to you. But if you feel strongly about it, if it's an open forum, you're allowed to talk about it. And I will tell you that when you look at the Virginia Supreme Court case, a lot of it turned on, because they do the analysis in looking at it. There's basically they find out, they have to look for First Amendment comparisons. They have to look at whether the speech concerns lawful activity and not misleading, and then whether the asserted governmental interest is substantial. And if both of those yield positive responses, then the court must determine if the regulation directly advances a governmental interest. It's all First Amendment law analysis. And the Virginia Supreme Court went through that. And when they looked at the blog, basically Horace was mostly talking about his victories, if not all. And it was really about, and it was on his webpage, which had to do Come Hire Me later on. So had it been a separate blog, and had he talked about every case, or had it been an abstract and some other cases, it might have been a different analysis, depending. But in this particular case, they found that it was commercial speech. It was not protected, and he was ultimately disciplined for that. He did try to appeal it to the Supreme Court of the United States, and he did not get certiorari. So, okay. So other than advertising, what about endorsements? You can like somebody on Facebook, and you can endorse people on LinkedIn. And in addition to that, you also have AVO, which I talk a little bit on here. And you may or may not know about AVO, but AVO is basically it's a forum for the consumer to ask legal questions, but it ranks lawyers, basically. It goes from 1 to 10. And even if you don't sign up for it, they've got you on there. And they have an algorithm that looks to see if you've been disciplined. So if anybody goes Google you on the internet as a lawyer, they're probably going to find an Avo site for you. You can claim your profile, which I did, and you can use it to build up to a 10 ranking, which I have done, and I use it as a marketing tool. I have a little badge that says I'm 10 on Avo, which you're allowed to do. What does that mean? Probably nothing, but it's there. And then you can use it, and basically consumers can ask questions that you can answer. But what you can also do is you can get endorsements from your client, which is one thing, testimonials. But you can also get endorsements from other attorneys. And some lawyers have put endorsements. Somebody from Michigan may say, this lawyer is fantastic. I don't know that lawyer. He doesn't know me. And that could very well violate the rules because you're getting endorsed by somebody it's potentially misleading because they don't have any knowledge about your endorsement. Much like if a client puts a testimonial and says, Mr. Parks is the best lawyer in the universe. He can beat any lawyer anytime, guaranteed. Now, the way I do my marketing, clients could go onto my Facebook page, they can go onto I have all the different mechanisms. They may put some testimonial on there that I didn't vet, and I don't write things for my clients to say about me. I ask them for their testimonials, and they go to the sites and post them. But if I see that somebody posted that, I got to take it down because I'm still bound by that, and you can't verify that I'm the best lawyer in the universe. I'm not, by the way. That'd be great. But you can't verify that kind of thing. So it's got to come down. And I've had to have a few clients come back to them and say, I very much appreciate your ringing endorsement. Can we take out these few phrases because it'll get me in trouble? And clients usually are pretty accommodating. What we also have is direct solicitations. So you've got Rule 7.3, which directs contact with potential clients. Solicitation is targeted communication stated by the lawyer directed to the specific potential client that offers to provide legal services. And the same rules apply to electronic solicitation. So the theme, which we've beaten into you a number of times and we'll keep doing it, is the rules apply no matter what the medium. And it's not so much that people ought to say, well, I want to violate it in a different way. It's people don't think about it. They may post something online. They may make an offhand comment that gets to somebody else. And so you really just have to be careful about what you're doing. And if you have any kind of questions, you sort of get to, in my opinion, you sort of get to a point where you kind of have a feeling that maybe this isn't, I need to check into this. If you have that little gut feeling, check into it. Check into it before you do something. To give you an example, a real-world example of where I had a potential client contact me, I knew the rule that, look, if a potential client contacts you, you can be conflicted out. Part of my practice is domestic relations work. It's not unusual for people to lawyer shop around town to disqualify somebody else, or it's just an accident. I had one where they just happened to talk to, the husband had come to me before the wife came to me. They both knew people that knew me, and it came that way. On my website, I have a Contact Us form. But you have to click a disclaimer, and this is, by the way, best practices that the bar says to do. Before you can click a question or hey, contact me, here's my phone number, you've got to click a little box that says, I've read the disclaimer, which then goes to the page with a disclaimer that says, any information, you're not my client, any information you can give me could potentially, is not potentially subject to attorney-client privilege, be warned. And that way, if somebody just reaches out and contacts me and I represent the other side, I'm now not conflicted out to represent the person I already represent. Whereas, if you don't have that kind of disclaimer and you're asking for somebody to contact you on your website, the LEOs are pretty clear that you could be conflicted out. If somebody just emails you, finds your email online and sends you an email, you don't have to worry about it because you didn't ask them to email you. Well, take it a step further. I've got a service on my website that says chat with me now, and I have a 24-hour service that you can chat with. So if somebody has a legal question at 2 in the morning, they're not going to get any legal answers, but they'll get somebody, and they can type and chat with this person online who will take some information from them, send me an email, and then I can contact them back when our office is open. Or if I happen to be awake at 2 o'clock in the morning, it's a particularly good case, maybe I'll really jump on it. So I didn't think about this, but I had somebody come to me to do a consult for divorce. The other side happened to know somebody that knew me, went on my website after hours, clicked the direct chat, gave the information to the person on the other end of the chat, which is somebody living out on the West Coast on this company, well, they didn't see a disclaimer because I didn't have a disclaimer for the chat. I didn't think about it. 2.5 years, hadn't had that problem yet. So, but I have this paragraph of information. And the other person hadn't hired me yet, but I've already done a consult. So actually I called the bar, and the answer, by the way, from the bar was, given what they told you, you're okay. You're not allowed to pass that information along if the person hires you, the other side hires you. But it really depended on what they told me. If they told me something particularly damaging, I could have been out of luck. So it's really important to think about things, make sure you know the rules, and don't violate them. All right, I'm going to turn it over to Alex. Appropriately, Alex Cloud, to talk about the cloud. Never gets old at all.
It doesn't. Never heard it before. Okay, so kind of as a baseline, is everyone in here familiar with what cloud computing is? If not, I'll certainly go through a more robust definition, but if everyone sort of knows what the cloud is, we can kind of proceed forward. So the cloud, in essence, is you are remotely storing your files. The physical comparison would be like you store your files with Iron Mountain and you call them up on the phone and they read the file to you. Cloud computing, through technology, in essence, enables you to look at these files that are stored in someone else's computer, on screen, on an iPad, on your iPhone, whatever you use, instantaneously. But keep that in mind. You are no longer storing your own files when you're talking about cloud computing. And so the first takeaway from Ethics Rule 1.6 is a reasonable care standard. And what the rule says, you have to exercise care in the selection of a vendor. You have to reasonably expect that the vendor or the provider will keep the data confidential and inaccessible to others, and instruct the vendor to preserve the confidentiality of the information. And by the way, this is when you are choosing to use cloud computing to store client confidential files. If you're storing pure research for your own edification, Rule 1.6 has to do with client confidences, so it probably would not apply to purely educational documents. But when you're talking about storing client files on a remote server, this is what you have to do to be able to do it. You have to examine the third-party provider's use of technology and the terms of service in order to know whether it adequately safeguards client information. And if you're not able to make the assessment on your own, you have to consult with someone who does. So what does this all mean in terms of the practice of law? Nowadays, in the 21st century, we're seeing something called virtual law offices. Essentially what a virtual law office is providing legal services online. That can be through a chat, that can be through running a paperless practice. Any number of possibilities are available, but all it means is an online practice of law. Sometimes it's a component to a traditional law firm, and sometimes it's an entirely online legal service. So there are three, and when I did this presentation, I looked at it through the paradigm of, if you are a small practitioner or a big practitioner, but a private practitioner of law, and you're looking at running a paperless office or advising people online, how would you look at this? And there are three legal ethics opinions to make this possible. The first, 1791, says that as long as you communicate with clients, communicate adequately, you never have to meet with them. Now for you trial lawyers out there, not having to meet with a client is probably the worst form of heresy. But for transactional attorneys or family law practice, for a large part, this is totally possible. If you email, phone call, voice over internet protocol, you probably don't ever have to meet with your client in person, as long as you communicate the point across. Legal Ethics Opinion 1818 enables paperless offices. So basically, as long as you store the client file and provide it to them in a usable format and take the required safeguards, you don't have to keep paper anymore. And then 1872, which headlined cloud computing and the virtual law office, addresses virtual offices and cloud computing. And in terms of a virtual law office, any non-exclusive office space or virtual law office that's advertised as the location of a law firm has to be a place where you provide legal services. And there are 3 criteria they use to evaluate that. How often does a lawyer use the space? Do any non-lawyers use the space? Are you sharing office with an accountant, with an engineer, with a doctor? And do you have any signage or other advertising that marks this as a law office? And where you see this mattering more isn't so much your traditional one-state practitioner, but let's say you're coming to Virginia, your spouse is in the military and you want to waive into Virginia by admission on motion. This used to be a requirement that you maintain a brick-and-mortar law firm in Virginia. So that's where some of this comes into play. It also comes into play with Rule 7.5, any kind of letterhead that you use. This is the evaluation that has to take place before you list your address as 123 Kempsville Drive. Do you use that, or is that the office suite you rent for 4 hours and share with 3 accountants and a doctor? Because what the bar wants to prevent is, again, what Kellam was talking about, it's lowest common denominator advertising. So they want to prevent someone who doesn't know anything about the practice of law from thinking, oh man, this guy's great. He's got 6 offices, 3 state practice area. They want to put the kibosh on that right out. So there is a proposed amendment to Rule 1.6, and it's Section D. But where Rule 0.6 currently wants you to take reasonable precautions when you store data offline, it's imposing, and this somewhat makes sense if you're taking the reasonable precautions anyways, but this is sort of, the first precaution was the front door, this precaution is the side door you're protecting, and it essentially imposes a duty to make reasonable effort to prevent inadvertent or unauthorized disclosure or access to confidential information. So before, where you were taking reasonable care to ensure this provider won't give anyone else access to my files, you also have to make sure that your files aren't walking out of the storage place. And the comment 19, which we'll get to on the next slide, in essence says your cloud computing has to be reasonably secure, and you have to have a reasonable system of safeguards in place that accounts for this technology to prevent someone who isn't supposed to look at the file from looking at it, and to prevent someone who isn't supposed to get the file from receiving it. And some of that has to do more with inadvertent disclosure. Don't email the wrong person. But some of this can come up in the cloud. I'm not going to read this whole thing. It is in your materials, thankfully, and it is part of the appendix. But a couple of examples where this may come up are things like iCloud or Google Drive or free cloud-based services that are offered. And earlier in the presentation, I said you have to look through their user statement. Google claims proprietary ownership of some of the information they put up. I'm not positive about iCloud, which is why we don't use it for confidential information. But some of these services claim when you put your information into them, it's theirs. If they do that, you've probably violated Rule 1.6 by putting confidences up there, because not only have you given it to someone who allows access by others, but you've given it to someone who may publish it or republish it or create derivative works off of it. And that very obviously is an inadvertent disclosure on your part if you didn't know, but you've in essence put your client's information out there when you shouldn't have. So be careful with some of these cloud services. The bottom line is take reasonable care, read the user statement, and make sure that no one else has access to the files except you and whoever you designate.
So why don't you jump to
Sure.
your favorite hypothetical? We've got about 15 minutes.
So 5?
Yeah.
Okay. How do you just mass jump?
Do it that way.
Is there an easier way?
Yes.
Okay. So this hypothetical touches on a lot of things we've talked about. So your son asks you about a case you're handling. Curious as to how your son knows so many details about the case. You ask him where he heard all the information. He tells you someone tweeted about it. You discover that the opposing party, who's represented by counsel, posted publicly accessible tweets about how your client was a scumbag, was lying about the claims he asserts in his embarrassing slip and fall injury and fracture of his tailbone, how the jury will think he's a liar, and how he wants to talk to you and give you a piece of his mind. Also, for this hypothetical, assume that this tweeter has hired an attorney. So there's a couple questions with this. The first, this guy is tweeting about your client. Can you tweet back in your client's defense? Second, can you take this guy up on his offer? He wants to give you a piece of his mind? Talk to him. And the third question, does the analysis change, in essence, if this is a criminal case? Deliberately hosing down a floor with a caustic industrial-grade lubricant that caused slip and chemical burn injuries in order to ratchet up convictions for the upcoming election. Does the analysis in 2 change as well, given this new deviation? So the first rule to consider with question 1, can you tweet back to this guy who's pretty obviously slamming your client in the press, possibly tainting the jury pool? And the one thing that Rule 1.6 protects, that was talked about in the Hunter case, you can't disclose confidential or potentially embarrassing information about your client. So if the client hasn't given you permission, and if revealing details about the case isn't part of your case, then you can't do it without his consent. And there are several ethics opinions that hold, even if this information is public already, you still can't disclose it. There's one that talks about a divorce attorney not updating a bankruptcy court that their client's previous disclosure in the divorce case did not match the disclosure they made to the bankruptcy court. That was held to be confidential, even though it was previously disclosed in court. So keep that in mind. The LEOs can be confusing, and you do need to consult each one of them. And the other thing you obviously have to do is make sure that anything you put out on the internet is truthful. I mean, Hunter versus the Virginia State Bar is similar, but not quite what you have in the hypothetical, simply because your case hasn't gone to trial yet. Nothing's been brought out in open court. So that probably errs toward the side of not putting it out on the internet. Second question, can you call this guy like he's invited you to do and let him give you a piece of his mind? Do you have any takers for the answer to this? It's a fairly simple answer. Yes? Yes, you are correct. The short answer is no. Party cannot waive this per comment 3 of the rule. So even if they're banging on the door in your office, if they're hitting your email up, they're posting on Twitter, Facebook, wherever, I want to talk to you, I want to tell you off, unless your attorney tells you that it's okay, you can't do it. And that's the end of that. So question 3A, we have a rule shift in terms of he's putting all his stuff out there in the public. He's criticizing you, saying you're lying, you trumped up this charge, you're trying to get up convictions for the election. But what can you say in response to that? Rule 3.6 governs here. It's a different rule, and it specifically has to do with criminal cases and the communications that you put out to the public. It governs both prosecutors and defense attorneys alike. So if this guy's attorney was posting these comments, obviously he may have some other problems. And it concerns pretrial publicity for jury trials. And the key word here is jury trial or a potential jury trial, because there is a wrinkle that we can bring up about that. So essentially, anything that you know or should know that has a substantial likelihood of influencing or interfering with the fairness of a trial by jury, you can't say anything that touches that. So, and there are, before we get to Gentile, there are a long line of ethics opinions, published cases that delineate, at least as a prosecutor or a defense attorney what you can put out to the public. It's okay to say what they're charged with, if there's been an arrest, if there's a person of interest, but you can't really get to the meat and potatoes of your case. Now, Gentile versus the State Bar of Nevada gives defense attorneys, anyways, a First Amendment right to respond to any prejudicial press conferences that are against their client. Now, I think perhaps maybe if it applies to one, it may apply to the other, but essentially in Gentile, his client was a former police officer, and his stance was that his client was being thrown under the bus because things had gone missing from evidence, money and drugs were gone, and the police and prosecution very publicly said, this is gone, we think it's this guy. And Gentile took to the press to defend his client in order to stop jury taint. And then Gentile essentially said he has the First Amendment right to do that, to maintain fairness. And then the ABA responded by putting in a safe harbor provision in their model rules of ethics. The problem, as it applies to the hypothetical in Virginia, is there's no safe harbor in Virginia's rules. So you do have this constitutional right if you're a defense attorney, but there's no safe harbor and you're a prosecutor, so Gentile may not directly apply at all, and you may just have to sit on your hands. But the takeaway here, be extremely careful about what you say, if anything, to the public, to the press, but most importantly to the internet. The press generally has limited publication. You turn on the TV at 9, at 10 it's over. Once you put it out on the internet, there's no taking it back. It's out there, it's on someone's server, and there's no realistic way to really track it down and remove it. So keep that in mind.
So in our materials, we obviously have a lot more information about everything we've talked about in the materials. We have other hypotheticals with all the answers, which with most legal, ethical things, it's maybe. We have a couple of no's or yeses, but a lot of times it's maybe, probably. And having practiced for 15 years and now on my own for 3, again, if you have any, if it's not a clear-cut answer to you, look it up before you do it, because you don't. Even if you could be right, you don't want a bar complaint, because bar complaints, I have, knock on wood, haven't had one yet. But anybody can file one, and if it's questionable, you're going to have to file a response. It takes a lot of time and energy, and although we obviously try to do everything we can for our clients, it's also a business, so we want to make sure that everything else. In the materials at the end, like I said, I have all of the things I mentioned as an appendix that you guys can download. Do it the long way here. Okay. If you just simply write that down, it's the Google short line. It's not in your materials, so if you want it, write it down. If you can't get it for some reason, just let me know. Our information is, my website's at the beginning, which has got my contact information on it. All you have to do is click this link. When you click this link, it'll take you to Dropbox. You don't need a Dropbox account. It just simply takes you to the file. You download the file. It's only 3 or 4 megabytes, but it's got all those LEOs and the cases we've talked about for you to go through. I also downloaded the AmLaw blog article, which is a study which talks about all sorts of blogs and information. If going through materials or even moving forward, if you guys have any questions or anything that pops up, I'd be more than happy to make myself available. I'm sort of a geek about this stuff. I write about it a lot. I teach about it a lot. I really enjoy it. I try to stay up on it, both to promote my business as well as to keep my bar license. So I just want to thank you guys on behalf of Alex and I for having us today, and thank you.